Welcome back to this third segment in this law session on judicial review. Before the break, we were looking at standing, and I want to pick up on that straight away and move on. The idea of standing, of course, as I said, is if you're bringing judicial review proceedings, then you must show that you have standing. And generally, there will not necessarily be a difficulty when you're an individual, because by and large, you will have, of course, been individually concerned with the particular thing under consideration. So the courts will always recognize sufficient interest in cases where you're looking at a person's personal right and interests, and which are allegedly directly affected by a public decision. But when you look at, for example, a situation where you have an interest groups, now the courts may of course recognize sufficient interest of an individual to challenge a public decision if, for example, you're looking at that person being an interest group or a pressure group. How does this work? Well, the courts will always recognize the interest of organizations to challenge administrative decisions which affect their members. The case for this, of course, is RV Liverpool Corporation ex parte Liverpool Taxi Fleet Operators Association in 1972. The courts, if it is about your members and to do with a matter which affect your members, the courts will usually consider that there is sufficient interest. The courts may also recognize sufficient interest of an organization to challenge a public decision where it harms the public interest. Now, the point is that when you look at the Greenpeace case, the courts considered that it could bring judicial review proceedings. But when you look at the case of Inland Revenue Commissioners and National Federation of Small Business, the court said that the National Federation of Taxpayers did not have sufficient interest to challenge a decision by the Inland Revenue Commissioners to entice tax evaders to pay tax by granting them some kind of amnesty for past tax evasions. The idea was that the National Federation of Small Business was saying, well, some of our members might be affected. So if you're going to allow, for example, big companies on Fleet Street to pay tax by granting them an amnesty, then you should open that up to small businesses. But they couldn't point to a particular member who was affected. It was just on behalf of their members. And so when you look at standing in this regard, it tends to show that the courts will not necessarily give standing to an interest group or a pressure group just because it may affect their members. When you look at the ex parte Greenpeace case, the courts found that organizations like Greenpeace, who have got thousands of members and experts who are committed to environmental protection, they may of course have an interest in challenging a decision, because it may very well be that when you're looking, and in that case it had to do with a nuclear processing plant near a national park, they consider that they may very well have that kind of interest where they would seek judicial review proceedings. So the idea, of course, is that an individual normally will have standing, but when you're looking at groups, please look at how the courts have looked at the various groups from the Taxi Fleet Association right through to Greenpeace. You must meet the timeline in that you must bring it within 3 months, because other than that, you may very well lose that right. Now, there are various statutory limitations in respect to the time limits. Now, when you look at time limits, one of the things to also consider is ouster clauses. Now, it is a little bit of a side foray, but I put it on this topic because it doesn't fit anywhere else as well. When you look at ouster clauses, which are also called conclusive evidence clauses, they basically work like this. They say if a decision taken by a body is final, then what they're seeking to do is to oust the jurisdiction of any kind of justiciability. So if, for example, you have an act which says the decision of this tribunal is final, then you may very well not be able to bring judicial review proceedings. And these are called either conclusive evidence clauses or ouster clauses. And they are clauses which are inserted by the lawmaker with the intention to exclude usually appeal or judicial review. Now, what we have seen with the cases is that the cases have tended to show that whilst it may exclude appeals, an ouster clause may not be sufficient to exclude judicial review unless it does so expressly. Now, the cases to consider are cases of Ex parte Gilmore, the case of Southeast Asia Firebricks, the case of Anis Minnick. Now, in RV Medical Appeal Tribunal Ex parte Gilmore, we see there that the decision which was made in respect of Mr. Gilmore, he was assessed at some ludicrous, he was totally blind, but he was assessed at a percentage of being blind. It was clearly a wrong decision, but because the Act said that the decision on any medical question by a medical appeal tribunal shall be final, the question then was this final? Lord Denning in the case famously said, final should not mean final as to judicial review, as it were. So it may be final as to any further appeal, but not final as to JR. In the case of Southeast Asia Firebricks, what we see the court saying is that when you consider finality as to JR, it must clearly be said. And when you look at the case of Southeast Asia Fabrics, it actually said this clause is final as to certiorari and mandamus and all of this. It was clearly considering judicial review as to the finality of that as well. Now, huge case, Anis Minnick and Foreign Compensation Commission. Now, the relevant act provided that the decision of a public body, in that case the Foreign Compensation Commission, shall not be questioned. But the House of Lords found that the words could not exclude the supervisory jurisdiction in respect of JR. Now, it is interesting because Anis Minnick has kind of thrown the cat amongst the pigeons, as it were. The problem with Anis Minnick is that Anis Minnick has meant that the blurring of the line as it relates to the distinction between errors of law and errors of fact seems somewhat blurred. Let's consider Anis Minnick. In Anis Minnick, what had happened was that the Egyptian authorities had nationalized property which belonged to a British company. Now, the company was later sold to an Egyptian organization. In 1959, the UK and the United Arab Republic, as Egypt had come to be known, came to sign a treaty for the return of sequestrated property other than property sequestrated in a period during which Anis Minnick property was sequestrated. Now, the FCC, the Foreign Compensation Committee, was meant to provide awards for companies such as Anis Minnick, in other words, those excluded from the treaty. Now, the FCC, which was meant to implement this, stipulated that applicants and their successors must have been British nationals. Now, because Anis Minnick had been sold to Egyptians, there could be no compensation for the original British owners and who were the owners of Anis Minnick, so they were not compensated. Now, when you look at the act that dealt with this, it did contain an ouster clause which said that decisions of the FCC shall not be called into question in any court of law. Well, the House of Lords looked at the ouster clause, and the House of Lords said what that means is that the court cannot question it if it was reached, if the decision was reached correctly. Now, in order for them to determine if the decision was reached correctly, would that not mean that they would have to look at it substantively? And Anis Minnick does appear to have blurred the line somewhat. The other requirement, of course, is that you must have exhausted every alternative route before you go down the route of JR. And of course, you must also make sure that in bringing your action or bringing proceedings for JR, that you have got a ground. And there are the three grounds which different commentators set up different purposes and grounds, but the three grounds that you will generally discuss on are: you can bring JR proceedings if a body's decision is illegal, irrational, or there is some impropriety as it relates to the procedure. And when you look at the case of Counsel for the Civil Service Union and Minister of State for the Civil Service, which is the GCHQ case, we see Lord Diplock offering a threefold classification in relation to grounds, and that is what he says, is that you may of course bring judicial review proceedings where there is illegality or irrationality or procedural impropriety. Now, this is the classification that we will consider as we go through these. So, based on the GCHQ classification, then, let's look at the things that, for example, will amount to illegality and irrationality and procedural impropriety. Well, if we start off with looking at illegality, illegality says that if the action or decision which is taken by the body is taken with no statutory or common law authority, or indeed it is in breach of the Human Rights Act 1998, including issues relating to a disproportionate interference, or where there is an error of law, or if there is a failure to act, or if you've acted in bad faith, or if you've acted for the wrong purpose, or if you've acted inconsistently with the purposes of an act, or if there's an abuse of discretion. Any number of these will, of course, give rise to an action or a basis for illegality in respect of JR. Now, irrationality covers decisions that the court deems outrageous in their defiance of logic. Irrationality basically says it's the kind of decision which would have been arrived at if another court sitting could not, in all conscience, take a similar decision based on all the evidence before it. Now, as it relates to procedural impropriety, of course, it covers public decisions and actions which were taken without following the appropriate procedure. Now, if we look at an expansion on these three areas, illegality, and I'm not going into extraordinary depth with these, I just want you to take on board some of the main points in relation to this. Now, illegality looks at the doctrine of ultra vires, and it looks at persons operating outside of the power that have been given to them. So illegality looks at how an action or a decision has been reached. So you don't have the authority, for example. So if you lack the authority or you go beyond your authority, an interesting case for this is R.V. Richmond upon Thames City Council, ex parte McCarthy, where it was illegal for the local planning authority to levy a fee of £25 when they didn't have the power to levy fees. So if you go beyond what you are allowed, then that may very well be that you've acted outside of your authority. If you act in contravention to the HRA, you may equally have gone outside of your authority as the body finding in that matter, because it would of course be a situation where the Human Rights Act does engage when you're looking at certain matters which are coming before the courts. So when you look at the compatibility of JR proceedings with human rights, then it is something that may very well be considered. Case to consider here, of course, is Kingsley and the UK. So do bear in mind that these are matters that would go to illegality. If you make an error of law, so if a public authority is to act within its power, it must conduct itself according to law. If it doesn't conduct itself according to law, then again, its actions may be considered illegal and as such may then be held up to scrutiny by way of judicial review proceedings. Now, when one looks at the Anis Minnick and FCC case, that would fall under the error of law and the illegality type scenarios that are mentioned in respect of this. If you fail to act as a public authority, then that may be illegal if you're under statutory duty. Now, it is a somewhat difficult here, but the point is, if you don't, you may find yourself up to scrutiny. Equally, if you act in bad faith, so you know what provides for in a certain situation, but you go against that. And the Attorney General and Fulham Corporation is a good one, where the authority was entitled under statute to open non-profit washhouses for the public, but instead it uses power to open a commercial laundry. Now, all of these show, among others, that illegality will operate as a ground in order to bring judicial review proceedings. We are going to take a short break, and on our return, we will look at the other two areas and we'll also conclude in respect of this area.